We have today published our first set of recommendations for reform of contempt of court laws. Our recommendations would make the law clearer, more accessible, and more modern. We recommend that there should be 4 forms of contempt liability. The first would arise where a person breaches a court order or undertaking. The second form of liability would arise where a person publishes material which creates a substantial risk that the course of justice in active proceedings will be seriously impeded or prejudiced. To establish this type of contempt, the applicant must prove that the publisher was aware of a risk that proceedings were active. Currently, criminal proceedings become active after a person has been arrested. We recommend that proceedings should only become active later, once a person has been charged with an offense. Our recommendations would retain the current high conduct threshold. We think that the publication of certain details, such as the name, age, nationality, and ethnicity of a suspect, is generally unlikely to create a substantial risk that the course of justice will be seriously impeded or prejudiced. But these are not fixed categories of information that can always be published. Whether information crosses the contempt threshold will always depend on the facts and circumstances of the case. The third form of liability would arise where a person engages in abusive, threatening, or disorderly behavior that disrupts court proceedings, and the conduct was witnessed by the judge or a court official. Any conduct that does not fall within one of these 3 categories could fall within general contempt. This would be committed where a person interferes with the administration of justice in a non-trivial way, or where their conduct creates a substantial risk of such an interference, and they must have intended to interfere with the administration of justice. Our summary of the report provides a simple explanation of these and our other recommendations.